WDXFM around the world at WDXE.com. And, of course, now live on Facebook and YouTube with Stan Pierchoski and Bulletproof Estate Planning. Stan, welcome back into the studio this Friday morning.
Good morning, Jeff. Good morning. How are you today?
Very well. Very well. Thank you.
Did you enjoy Father's Day last weekend?
Yes, we did. I had a great Father's Day. How about you?
Yeah, it was good. We had some folks up and a couple of the other fathers in the family, and we enjoyed some time together. The only one who couldn't make it was my daughter, but other than that, we had a pretty good turnout. And one of the things that I had a lot of fun with was my wife. You know, when we had our meal, she made a blessing, and it was sort of geared toward fathers and what they do. And afterward, I said to my sons that were there with their girlfriends, but they're not fathers yet. Okay?
Yes.
And I told them, I said, if for those of you who are not fathers, looking right at them and said, I highly recommend it. And they looked at me funny, and I said, yeah, well, think about it. You have kids, you raise them for 30 years, and then on Father's Day they get you cool tools and stuff. You get these gifts that are really cool. They got me some stuff that was pretty neat.
Well, good deal. So you got some nice gifts then.
Yeah, well, pretty good. Yeah, I'm pretty easy to please. So
yeah,
but yeah, it was interesting. So maybe someday. My daughter has some children, so I'm actually a grandfather with the second one on the way. So there's still hope for them to chime in and participate.
Very good. Very good.
So
Very good.
Well, anyway, here we are again on Bulletproof Estate Planning. I'm your host, commonly known as Estate Plan Stan.
Indeed.
So I'm Stan Pierchoski from Pierchoski Estate Law, Pierchoski Elder Law, office located on the beautiful downtown square in Pulaski. And we talk about estate planning on this show, and we're going to pick up where we left off pretty much last week. It's kind of informal. I sort of progressed through the topics from one end to the other, with an informal structure. So we always encourage calls, of course. And when I have my seminars, which I'll tell you about one coming up, but we have my seminars, I always have a question and answer period at the end of it. And I always tell people, if you got questions, write them down and bring them with. If you develop them during the presentation, jot them down. At the end, I'll stay as long as I need to answer any and all questions. If they're private, catch me on the side. But I often say the question and answers are my favorite part of the presentation because it tells me real world things that you guys are experiencing or what you thought or what you need, and we really hit the road running, get down to where the rubber meets the road when people ask questions. So I really enjoy that part of it. So we have tried to design this show, and talk radio in general, but for this particular show, don't be afraid to call in. If you got a question, call. That's what we're here for. I look forward to it. I often tell people there's no such thing as a silly question. If there is, I'm guilty of it probably at least once a day. So if you don't know something, the thing not to do is not ask, I guess. Let's ask and see what the issues are. You'd be surprised at where a question can lead you and how times it can solve a problem. You can start, you may not know what to do. You have a question. Next thing you know, you have a path you can start to follow that's headed toward where your goal is going to be.
Sure.
So please, we encourage that. Call in. The number to call in is 931 762 76. That's right.
766.
It's one of the two, right? 766-9393.
That's right.
Pretty easy number to remember. So call in and ask a question about anything. Let's at least limit it to estate planning.
Yeah. In the realm of estate planning.
That's right. If you want to call in and ask me what my favorite color is, I guess that's okay. But anyway, like I said, we're kind of progressive on this. And
sure.
Last week, over the last several weeks, we talked about a last will and testament. We talked about how that goes into probate. We talked about the probate process and some of the disadvantages of probate, being a court procedure that's kind of cumbersome. Then we moved into what a trust is and what it does. And we were talking about the revocable living trust and how that was a complete probate avoidance technique. We talked about how if you have a trust, how to put property in the trust. Remember, we used the concept of a deed.
Yes.
Where you put property in a trust. Really what we do is vest that property with the trustee of the trust, which is typically you, and then it's in the trust. And once it's in the trust, now when a point of death happens, or if you're a couple, you got your first death and the second death, when you get to the point of descent and distribution, which is after death, the trust distributes property. If the property's in the trust, then it gets distributed probate free.
Mm-hmm.
Okay? So I think where I was kind of last week toward the end was, there were 4 disadvantages of probate that I brought up. And I was talking about how the trust cures those disadvantages. And I think I went over the first one or two, but I'll go over it again. The first one about probate was it can take a long time. It takes anywhere from 12 to 16 months to probate an estate because, for one thing, creditors' rights stay open for 12 months after death.
Right.
So, if you open your probate 2 or 3 months after somebody passed away, you could possibly close it in 9 months because creditors' rights are open for 12 months after death, not after you open the probate. Which brings up an interesting question. Because creditors' rights close 12 months after death, some people have asked me and said, I know Daddy had these debt, they had this and they had that. Can I just not open it? And the answer is, well, you can not open it, but that won't fix the problem because about 9 or 10 months into it, if you've got a valid creditor, or at least a substantial creditor, they will contact you and say, if you don't open the estate, we will. Now you're thinking, okay, Dad's estate or Mom's estate, and here's some third party that has nothing, no relative, nothing to do with Mom or Dad. It could be a credit card. It could be the hospital. It could be, they're going to try and open the estate and become the administrator of the estate. And that happens more often than you think. And so they have a right to do that. Anybody can open a probate estate and petition the court to be the executor. Now, when they do it, their interest is somewhat self-serving because they want to get paid, and I get that. I'm not being condescending toward the creditor. If you're a valid creditor, you need to get satisfied,
Sure.
right? And so, let's say you owe a substantial amount. Sometimes if it's a little bit, they just don't bother. Like credit card companies with unsecured debt, they just really don't bother. But let's say you owe $20,000 in medical expenses. They're not going to just let that go. They will open it without you. Now, whether or not the court will appoint them as the administrator, don't know. But the court will appoint somebody. So surprisingly, creditors get appointed to be the executor over somebody's estate more often than you think. So
that's amazing.
You don't dodge them by just not doing anything.
Yes.
And they know their rights run out after 12 months. So if it doesn't get open, the law is not that willy-nilly that you could just avoid a creditor by just sitting on your hands and not doing anything.
Right.
Right. So they can force it. So, but anyway, once it is open, like I said, you got creditors to deal with it. It takes 12 months, 16 months sometimes to get through it all. That's the average. And it's kind of a wide range, 12 to 16 months. But the point is it takes a while. It doesn't happen very quickly. Mm-hmm. And when you do a trust, it can happen rapidly. I think I did talk about this last week where you just literally, at the moment of death, the person called the successor trustee is immediately empowered with all the full force and effect of trust law and can start dealing with the property. They can distribute it. They go to the bank. I think the example I'd like to use, because I've seen this happen many, many times, you go to the bank and you say, I would like to take over Dad's account and distribute it to myself and my 2 siblings. And the bank's going to say, okay, that's cool. What authority are you acting for your father? And, you say, well, I'm not power of attorney because he's passed away, so that does not survive death. Mm-hmm. But I am the successor trustee of his trust, and this bank account I'm here talking to you about is vested with the trustee of the trust, so we know it's in the trust. And so that you show the bank the documentation that says the person's the successor trustee, then you show them a death certificate to show that the owner of the bank account has deceased. They will recognize that immediately and say, okay, what do you want to do with your father's bank account? You have the authority to deal with it. And you say, well, there's me and my 2 other siblings. And,
yes.
He said in this trust we're each supposed to get a third of it. You don't even have to explain this to the bank. I'm doing it for the general example.
Yeah,
principles.
exactly.
And you say, okay, well, how much is in this bank account? You say, well, there's $30,000. Okay, I'm going to write 3 checks. One for $10,000 to myself, one for $10,000 to my brother, one for $10,000 to my sister, and then I want to close the account and just terminate. I say,
Yes.
okay, you do that.
Yes.
You hand yourself 1 check. You go home. You hand one to your brother. Hand one to the sister, and that asset has been distributed just like that. It's gone. No court involvement. No letting all adverse parties have 30 days to object. On and on. It's just now when you have a deed, it's the same thing.
Sure.
Was that going to be a question? But
I do. I got a question.
Okay, go ahead.
I'm going to feed you a little bit with a question here because this has crossed my mind.
Yeah.
You have a trust set up, and you've funded the trust with whatever assets that you wanted to put in the trust. But let's say you buy another piece of real estate after you've created the trust. You buy another piece of real estate, or you develop another bank account of some sort.
Sure.
Are they automatically in the trust, or is there something that has to be done?
Well, that's an excellent point. Excellent point. Because when we talk about funding, I often say it's kind of a one and done. So let's say you start the trust today, Obviously, your house, your bank account, your stuff now is not in a trust because you didn't have one. So we create the trust. We move all your stuff into it, like I talked about during the
Right.
funding. Right
Right.
now, the question is, okay, let's say you just have one piece of property where you live.
Yeah.
And so, a couple of years later, the lot next door opens up, and you want to buy it because you don't want somebody moving in and building.
Yeah.
And you say, okay, I want to buy it. Well, you've already made the decision to buy it. Go ahead and do that. Now, what I recommend to people is you don't really have to put it in the trust. Since you've decided to buy it anyway, when you get to the closing, you tell the closing agent, say, oh, by the way, when you make out the deed, please make it out to me, Jeff Hood, trustee of the Hood Living Trust. And now it's in the trust from the get-go.
Ah.
But I would often tell people, sometimes when you do property, and you know this probably as much as I do, you deal with title insurance companies. And sometimes they have their own rules, and it's like my way or the highway sometimes. But if for some reason you forget or somebody refuses to do that and they actually do deed it to you or you and your wife, then you just bring it to somebody like me and we just do another deed and put it in the trust. But for the most part, you can take title in the trust to begin with. Same thing with a bank account. Your bank account's in the trust. All of a sudden, the bank down the street has a CD with great interest rates, and you say, you know what, I'm going to go put a little money in that CD account because it's 5-6%. It's pretty cool.
Right.
So you go open it up, and somewhere along in the paperwork, it's going to say who's the owner of the account. And you just put down, Stan Pierchoski, trustee of the Pierchoski Living Trust. So when the bank account is created in the name of the trustee, so it's there at its inception. So it's kind of a one and done when you first do it, and if you acquire stuff like that, where you are with third parties, that's right, you can acquire them in the trust at the time you acquire them, which
So
is the
it's-
best way to do
So
it.
it's a good idea for your long-term assets, such as your real estate or savings accounts, to put it in the trust.
Well, actually, if it's a revocable living trust, which is what we've been talking about so far, you really want to put everything in. And everything is because if it's in the trust, it avoids probate. If you leave something out, you're going to be dealing with at least one of our abbreviated forms of probate to deal with. Yep.
Interesting.
So, and the 5 categories of property are real. Well, there's really only 2 categories of property. There's real,
Yes.
which is land. And now a lot of people say, well, does my house have a deed? Real property is land and everything permanently attached to it.
That's correct.
So if you buy a piece of land and there's nothing on it, and then you build a house, you don't get another deed for the house. What you get, you have the same deed because the deed is the meets and bounds description of that piece of property and exactly where it is on planet Earth.
That's correct.
And if you build a house on it, where you'll see that is you look at your tax card, it'll say land value, $20,000 for the lot, improvement value, $300,000 for the new house you just
Correct.
built. Total market value is the sum of the two. So
Sure.
there's only a deed for that piece of land. So the two categories are real property, which is land and everything that's permanently attached, and personal property, which is everything else. Now, personal property is your stuff, your pots, your pans, your tables, your chairs, you name it, your untitled property that you
That's
own by
right.
possession. We talked about that. Now, there's other personal property that you have that I tell people I cannot put in the trust for you. So if people hire me to do a trust plan, I'll draw up the deeds. They'll be ready at the signing. I'll draw up an assignment of personal property that puts all your stuff in there. But you have other personal property that I can't put in for you because you own it with a third party, which is usually in the form of a financial institution like a bank.
Right.
So you have a bank account. That's personal property. The money in there is personal property. But I can't put that in there because if I go to the bank and say, let me sign Jeff Hood's savings account into a trust, they're going to show me the door. They're going to say, okay, we got a contract with Mr. Hood and you're not on it.
Yes.
So I can't do that. But, we talked about what you need to tell the bank to move it. And then the other kind of financial stuff you might have is maybe some investment type stuff, like an Edward Jones or Raymond James account where investment or Fidelity. And the other thing could be like, the other things are things that are beneficiary driven, like retirement accounts or life insurance. Those we deal with the beneficiary. So those are the 5 categories. It covers all the property you have. And if you put all that stuff in the trust, then it's all there, and at death, it all passes free of this probate. And so when we talk about probate free, I just got done talking about the speed of how your heirs can distribute the property. That happens pretty quickly. The other thing that's of an advantage is the cost. The cost is a whole lot less than probate because, and the big difference with cost, I remember saying, is when you talk about the cost of probate, it is not a cost to you directly. It's an indirect cost because it's money that comes out of your estate that does not go to your kids or whoever your heirs are, right? So they end up with the residual. So if there's a lot of cost for probate, it's just coming out of the descendants' pocket. Where when you do a trust, it's a living trust, it goes into effect now during life. So that is an expense to you during life because you have to hire somebody like me to draft the trust. So
Correct.
it's a fraction of the cost, but it's slightly different posture of a cost. But it's a lot less. It's a lot less. The third thing that we can avoid, and this is one of the things I like a lot, and that is that when you do a trust, it is 100% private. When I mentioned earlier, the probate procedure, 100% public.
Yes.
You walk into Christy Gang's office over here and say, I want to see the estate of Jeff Hood. And she has to show it to you.
Yes.
Hand you the file. So look at your will. You say, read where Jeff decided his stuff was going to go. I mean, it's a public process. Our court system is 100% public. Now, that bothers me, but when you do a trust, it's completely private. Nobody has to know what's in your trust unless you tell them, including your children. I mean, they'll find out in the due course of time. At death, the trust is produced, but it's not recorded anywhere. But people that are named in the trust get to see what they're supposed to get once that happens. But
Yeah.
I tell people, you can come in my office and administer this trust around my big conference table in private, or you can do it around the kitchen table at home. Nothing has to be published in the paper. Nothing has to be published at court where people can walk in and see it. Absolutely nothing. It's completely private. Now, I think that's a big advantage. But anyway, like I said, I think the publicness of it is maybe, and me not liking that, is probably remnants of the 10 years or so I spent practicing criminal defense work. So I like the private part of it. And a lot of people have trust, and they say, you know what, my kids are here with me during signing. They know everything that's in it, and that's okay too. It's your private document. If you want them to know about it, that's your choice, and you can do that.
Yeah, but it gives you control.
It does. I mean, it doesn't change anything that they know it. But if they know what's in it, that's entirely up to you. The point is, if you want it to be private, it can be.
Mm-hmm.
So that's the third big thing. The last thing about it being probate avoidance that I think is the biggest advantage of a trust. And I could probably spend a couple of Friday mornings talking about this, but we'll hit the high points. And that is, remember I said at the end of the probate process, when you reach the distribution phase, when it's time to start divvying out the property to the kids. Just assume kids are your heirs. It can be anybody,
Yeah.
but whoever you're leaving to. So, I got 3 kids. So it's now time to start cutting the checks or deeding the properties and stuff like that. We said in a probate process, it's what I call outright distribution, meaning you give it to them, and the key words are, once you give it to them, ownership is complete. You cannot put any terms or conditions on it. Okay, you cannot tie any strings attached to it. So you can't say, I'm going to leave you this money, but I really would like you to tithe to the church 10% every year the rest of your life. I mean, you can say that. It's just not it's an unenforceable promise.
Right.
You can suppose you say, I'm leaving you the family farm, but I don't ever want you to sell it to anybody outside the family. Well, once you give it to them, if ownership is complete, they can do whatever they want.
Yes.
Now, out of respect, they might not sell the farm, but
Right.
if they did, there's no cause of action because of that.
Yes.
Now, I'm going to talk probably this week or probably next week. There is a way to do that with a will. It's called a testamentary trust, but I'm not a big fan of them because of all the baggage that goes with them. But, if you're listening and if you've heard some of this before, I'm not referring to that. So we have this outright distribution. Now, in a trust, you can put whatever terms and conditions on it that you want, absent an illegal purpose, okay? Now,
Yeah.
the next question might come and say, well, gee, Stan, what kind of terms and conditions would I put on an inheritance? And I'm telling you right now, I could spend 3 hours talking about the common things I see people do. If you think about it a little bit, you're going to come up with it.
Yeah.
So you think about your kids. Let's just use your kids. Think about your kids. And if you tell me my kids are great, they're lily white and they're pristine, they're all financially responsible, and I mean, if they are, God bless you, you're probably the only one, right? But if they are, that's great. But most of us, kids have issues, right? Future issues, past issues, present issues. And so what kind of terms and conditions would you want to put on inheritance? Well, let's think of some of the simple ones. Suppose you have a child, I don't know, he's young, late teens or maybe early 20s when something happens to you. And you really would like this child to get a higher education. I mean, let's not limit it to just college. Let's just limit it to what we call post-secondary education, something after high school. That would encompass college, trade school, VOTEC, and anything. And you would really like them to do that. And you want to make sure that they have the wherewithal to do it, because a lot of folks that do want to get a higher education don't, because they can't afford it. because
Right.
it's pretty darn expensive.
Yeah.
It can be. And so you can incentivize. You can say, listen, here's some money, but I want you to use it for education. Okay.
Yeah.
Now, and it's kind of conditional. That's what it gets. You can't just say, well, I'm not going to get education, so give me the money anyway. You can conditionalize it and say, if you want this, you can have it, but it's to be used for education. Now, what you've done, you have completely incentivized the education. You've removed the barrier of not being able to afford it. So if the person wanted to do it at all, you've created a situation where they can. It's easy. It's painless. They're not going to be struggling for money for the next couple of years while they're trying to get this education. But you've given them, you paid for them, but you've conditioned that that's what it's to be used for. And that's why I say don't just say college. If that's what you want, you can. But if you just say education, it could be anything based on whatever their interests are.
Sure.
Which I think is a good way to do it. You have minor children, and minor children can't inherit. I mean, if you pass away and your kids are still minors, they can inherit. They just can't get it until they become an adult.
Right.
And in Tennessee, the age of majority is 18, and you may not want them to get it that soon either. I mean, these days, this is radio, but raise your hand if you don't want your 18-year-old kid getting a big inheritance.
Yeah.
But most of you are probably raising your hands. Okay, 25 at least. Maybe we do that almost routinely in our trusts. We don't give it to them until they're 25 because their brains just aren't mature enough. So
Yeah. There's.
but don't call in and ask about that. That's just a fact. So
It's just
we'll accept that as a fact.
Yes.
But during that time, you've got a 15-year-old child, and you want to give it to him at 25. Does he get nothing for 10 years? I mean, you can carve out and say, all right, I don't want him to get it to us at 25 because I don't think he's going to be responsible. So I want to appoint somebody that's a financial guardian. I don't want to pick somebody in the family because if the court picks a financial guardian, it'll probably be an attorney who will charge their hourly rate for stuff over the next 10 years. And
Yes.
it's going to be a great expense to that heir. Now, so you pick a family member to do it, and you give them the opportunity. We can carve out the standard examples. We call them ascertainable standards, which is we call them health, education, maintenance, and support. And so if the child, in that 10-year period before they get their inheritance, has a medical issue and they need to pay some medical bills, that falls into health. If they do want to go to college, it falls into education. If they need a car to commute to college, they can invade their inheritance under the support or maintenance. So
Sure.
it's kind of the necessities for that period of time, but it's not just say you get it when you're 25 and not a penny before.
Right.
Now, you could say that if that's what you want. The beauty of a trust is it is whatever you want and whatever you say.
Yeah.
But, we want to be workable because if you're leaving it to your kids because you love your kids and you want to help them and give them a head start, this is the way you do it because who knows what's going to happen in that 10 years between 15 and 25. I mean,
Sure.
You're not there because that's why they're getting their inheritance. So, but you want it to be flexible enough, but you also want to protect it so they don't get it and, buy a jacked up truck and have a big party and blow it all. Or just along those lines, suppose you have a spendthrift. I mean, I've seen this a lot. You got somebody that just, bless their heart, they maybe not be because they're not smart or do unwise things. That could be it too. But some people just blow through money like water and just can't. They just can't control it.
Can't manage it.
I've had people tell me, like a wife would say, if my husband passes before me, I just can't handle money. I'm just not good at it. I should not be in charge of it because I just don't know how to do it. And so if you got somebody that's not financially responsible, you might want to leave it to them in such a way that they can't just blow it all. And there's many ways you could do that. You can say you get a little bit for a year,
Right.
for 10 years.
Right.
Or you get so much at age 25 and another hunk of it at 30 and another hunk at 35. And the theory is if you're not financially responsible by then, you're probably not going to be.
Yes.
Or you could meter it out, have somebody else in control of it.
Sure.
And so, and that other person can have the absolute discretion that, okay, my son's not too good with money, so I'm going to give it to his sister to control it. And she'll use it for these good purposes,
Right.
Not foolish things. Now, I'll put in there some language that says, if my son, in the discretion of the trustee, my daughter, ever becomes financially responsible enough to handle his own money, and I'll leave it in the discretion of the trustee that I'm appointing, let's say my daughter, in her discretion, if he's ever matured enough and has become financially responsible, then the terms and conditions of the leaving, and this could be years after my death,
Sure.
she can turn it over to him, and he now controls it all, because the problem I was trying to solve has now apparently been corrected because
Yes.
he's now financially responsible. And when they don't get their own money and someone else controls it, that sort of breeds responsibility because now you don't just have it to blow. You have to ask for it. You have to have a reason for it. Then they'll give it to you if it's for a good reason. And when you do that several times, I see it starts to click with the person
Yeah.
that this is what the money's for,
Yeah.
not just squander and have a good old time and blow it. And then 20 years later, when you maybe really could use it because of circumstances, you've blown it. I like to use
Right.
examples sometimes. I had a gal for a trust client that said, I want to leave my inheritance to my children in trust, and I want to make sure that they can't blow it and stuff like this. She goes, I want to tell you, Mr. Pierchoski, she said, when I was young, I inherited from somebody, and I blew it. I just had a blast. I bought a car. I bought a boat. I just gave some to my friends. And it was all gone. And she
Yes.
said, when I look back now, she says, I could just kick myself because now I'm married, got kids, we're kind of struggling.
Yeah.
I could have used that inheritance for what they wanted me to do, and I just blew it all. She said, my kids are not getting that opportunity. They can hate me as much as they want, but they're not going to blow an inheritance
Yeah.
like I did. So
Yeah.
that's real life experience. Okay?
Sure.
So
Sure.
that kind of happens. So really, like along that point, they can hate me if they want to. Actually, you're doing them a favor when you do that. You are doing your kid a favor if you are controlling his inheritance so that he doesn't foolishly squander it.
Yeah, exactly.
I mean, most kids, you got a young child in here that comes
Yeah.
in now and then. I don't know, what is he, about 13 years, something like that?
Yeah.
All right, he's 13 years old. We really don't know how he's going to turn out when he's an adult. We don't know his personality just yet. Suppose he turns out to be an entrepreneur
Yeah.
and he wants to get into a business. And, what's it take to get into a business? A pretty good chunk of money
Yeah.
or a loan or
Some
something.
kind of
And
investment, yeah.
You're a young kid. You have no loan history. Their banks are reluctant sometimes without any history or
Right.
credit. You could say, listen, this is for, to start your own business. You can use this inheritance to start your own business. Now, that fosters that, but you don't even know what it's going to be yet. But you want it
Sure.
to be a good start or
Sure.
down payment on a house. These are the things that cripple young adults. You're young, you're 22 years old, you get married.
Well, the
have your
point is
first-
to avoid
yeah.
the wastefulness. And
That's
the-
it, right.
yeah.
That's right. And you can. Those are the terms and conditions we're talking about.
Right.
Now, some of them get a little more specific. Suppose you have an adult child with a drug or alcohol problem.
Yeah.
Again, your child's 13, you don't know. I'm not picking on them, but I'm saying, if something
Yeah.
like that happens, let's put ourselves in that position. And I use this example because I see it a lot. You'd be surprised. There's a lot of it out
Unfortunately,
there.
yes. I'm
now,
sure.
let's just suppose we're unfortunate enough and we have adult children. One of them has a drug addiction problem, substance abuse.
Yeah.
And you're thinking,
Yeah.
you're writing your will, you're writing your trust, and you have money to leave to all your kids, and you're thinking, gosh, I don't want to, if I leave money to this child, I know what he's going to do with it because he has this bad habit. And, you could literally, some of these drug addictions, you would absolutely be the instrument of their destruction, right?
Yeah.
If I leave him this money and it all goes up his nose and his heart explodes, that's kind of going to be my fault. And I don't want that. Now, what does that mean? I have to disinherit him and leave him nothing? Now, in probate, those are your choices because it is that outright distribution.
Yes.
So, but with a trust, you can say, all right, well, neither of those is a good choice. So how about something that's restorative or corrective in nature? And how about I leave it with someone else, or make
Yeah.
him a co-trustee over his own money with someone else?
Yes.
Okay. And now, the instructions I'm leaving the other person that's in control of his money, or the other person that's in co-control with his money. I like the concept of co-trustee because it's going to be teaching to that person. But the instructions are not to be used for a drug or alcohol purpose, right? So the child that's got an addiction, let's say at some point he says, I've had it, I want to go to rehabilitation. Can I use some of
Sure.
my inheritance money for rehabilitation? Well, let's just see if we could resurrect me and ask me, hey, kid wants to use the money for rehabilitation. Is that something if you were still alive, you would endorse? I said, absolutely. Of course I would, right? I
Sure.
would want the corrective action. So
Sure.
You can use it for rehabilitation. Suppose, and here's the way it works. The drug addicted child, you just can't let them make decisions because the addiction makes it for them. So they come to the other trustee and say, give me $5,000 out of my trust. The other trustee says, what for? And if the kid says, I'm not going to tell you. Then the trustee says, well, I'm not going to agree because it takes both of us to agree.
Right.
I'm not going to
exactly.
agree because I assume, because you're not going to tell me what it's going for, I assume it's going to be for some purpose that it's not allotted for.
Sure.
Now, compared to, give me $5,000 out of my trust, what for? Well, I'm going to Columbia State here, and I'm taking some classes, and here's the tuition bill, it's $5,000. Okay, I'll agree to that. They can even cut the check to the institution, so if you're worried, you don't say, here's $5,000, you go pay,
Right.
just in case, you know.
Right.
When I was in criminal defense, you see it all, you know. But now it's going to a good purpose, and it's being controlled. And we can put self-exacting language in that to say, okay, if this co-trustee says, okay, for 3 years or 5 years, I don't really see any drug or alcohol issues anymore. It seems like the person has turned rehabilitated and not going back to those old ways. Then we can have self-exacting terms that now trigger and say, oh, another conditional event. If they've reached that point, now we can put him as a trustee of his own money, a sole trustee of his own money. Because now the problem we tried to solve, which was money being used for the addiction, if it's 3 or 5 years went by and there's been no sign of that, the problem is cured. So there's no reason to have the controls. So those can get pretty involved. But you can see that, you know, if you have a child that's got some issue, and they all got some kind of issue.
Mm-hmm.
If you have special needs children, you know, they cannot own much property.
Sure.
Their qualification for benefits is very similar to long-term care for nursing home stuff. You know, if you own too much, they won't give you the benefits. And so you
Right.
don't want to leave your kid $50,000 and then all those benefits become ineligible for them. You want to maintain those all the time.
Yes.
So how do you leave the special needs child? Well, you create a special needs trust and leave it to his trust. I think we talked about that
Yes,
a little bit.
exactly.
So you don't leave it to him, but now you can put $1 million in a special needs trust, and the child still gets the benefits because they're not that person's individually. One of the things that's very popular, the condition, you can divorce proof it. Did we talk about that?
We did
last week?
talk about that.
You
Yes,
can
we did.
You can divorce proof property, and that's a big one that people are concerned about. You can creditor proof it and lawsuit proof it for your kids.
Yes.
Like I said, if your kid is an entrepreneur and gets himself into debt or gets sued, it's like, well, I don't want my inheritance paying for his debt. I'd rather he use it for a good start, you know, something
Right,
else. But
right.
but you know, so you can but you can protect it from that. And because if somebody inherits a bunch of money, you know, the lawsuits now are trying to go after deeper pockets than they are. You know what I mean? That's how that works.
Yes.
So there are all kinds of conditions. I mean, I could go on for a long time with examples that people have chosen, how they try to help people with their circumstances. Whatever your family dynamics are, there's a solution that we can do. Some can get pretty convoluted. Some people try to control from the grave a little too much, in my opinion. But
Yes.
the point is, you could, if that's what you wanted to do. Okay, you can put all these terms and conditions on it, and your trust will enforce it, because a trust is an enforceable instrument, and it's really in a unique position to be enforced. You know, when you get into probate, if somebody wants to challenge a trust, the court has to entertain the challenge. Okay.
Okay.
There's no bar against it. So we have what we call an interim clause, or sometimes known as a no contest clause. And if you put it in a will, the probate court instructs the court to really give it no weight.
Okay.
So it sort of invites challenges. Now, if you challenge a will, you can do that, but I mean, you still have to prove your case.
Sure.
Just challenging doesn't mean you get anything. You say, hey, I'm going to challenge this because Mom had dementia and she couldn't have really written one. But, you know, so you got to put on proof. But nonetheless, the court has to entertain the challenge. Now, when you have a trust, our legislature has said the interim clause, the no contest clause, is 100% enforceable. And even further, which is one of the areas the reason it got me in this area of law, is the legislature has said, as far as trusts go, that, let me back up a little bit. When you get to courts, when a trust goes into court, it's like, okay, how does the court know what to decide? And the answer is, they will enforce whatever you put in the trust. And the language they use, and if you read the annotated sections of the code, they said the trustor, remember that's the person who writes the trust, the trustor's intent is paramount. And absent compelling evidence, we will not disturb it. Okay?
Okay.
So you put in there all this stuff I'm talking to you about. And if somebody says, you know what, I'm going to take this to court. I want my money. I don't want somebody controlling it because they think I'm drug addicted. The court will enforce that. They'll enforce what's written in that instrument. Now, if you don't believe me, I'm going to tell you a story. And this story is an actual case. It's actually not one of mine, but it's a court case. I like to read court cases that come out of Tennessee and other states that are similar to ours to see what the court would do with stuff like this. You know, the way to be successful in law, any field really, You read what the courts do, and you do what the winners do, and you don't do what the losers do. Because when the court rules in favor of somebody, it's what they call precedent, stare decisis.
You hear it all the time.
Once settled, always settled. And if you read it, and the court says this, they're not saying that today. They're saying, well, we said this in this case 10 years ago, and that case said it in this case 50 years before that. So they're just saying the same thing again. It's stare decisis means once settled, always settled. So they're ruling on precedent. So if you know how the court's going to rule, you need to structure what you're doing to be favorable when you get to court.
Exactly.
And you will be successful every time. If they tell you they're not going to enforce something, and you say, well, I'm going to do that, and maybe I can argue in court that they will, I mean, good luck. You're not going to be successful. So I keep up with court cases. And I got to tell you this one, it's worth the time, because people ask me all the time, can you really enforce conditions? Terms and conditions. Can you really enforce tying strings on stuff? Like, I'm going to give my kid this land, but he can never serve alcohol on it, or he can never have those people down the street come visit him. Even the most ridiculous condition you can think of. Okay. Would the court really enforce that? I'm going to tell you the answer is yes, and I'm going to give you an example. I don't have the citation in front of me. Probably was about a year ago. I do it on one of my other radio shows. I kind of read over these cases. I'll give you the nutshell. And you can read between the lines, and you'll see where I'm going. The mom passed away, and she had a revocable living trust. Just the exact thing we're talking about, right?
Yes.
And she had two children, a son and a daughter. And it was a pretty sizable estate.
Okay.
I forget, but I mean, it was pretty decent inheritance, okay? Now, if you want to read between the lines, here's how she left it to the two children. She left half of it to the daughter, what we call outright, no terms or conditions, right? I mean, if you have a child that you're not worried about, you can do that. You can just leave it to him outright. But the son, there were apparently some issues, and you're going to hear in just a second what the very issue was. She left it to him. It was conditional. She said, if my son is not married to the woman he's married at the time of this writing, okay, then he receives his 50% outright, free of trust. Just, it's all his, do whatever he wants with it, right?
Oh, wow.
That's what outright means, okay? No terms or conditions.
Right.
But if he is married to the person who he's married to at the time of this writing, so you see how she's structuring it.
Yes.
If he gets rid of this one and married somebody else, he's still in good graces because, if you read between the lines, mom did not like this one wife, right?
Evidently.
The case was silent on why, but you can just use your imagination. But wasn't crazy about that person. So it was conditional, whether he's married to this woman or not married to this woman at her death. But if he was married to her, then his 50% went in trust and his sister controlled it. Okay?
Okay.
So, the son was part of the slow group and didn't quite get it. And he was married to her at the time of death. Okay. And he complained about that. He said, that is a violation of my right to own property. It's a violation of my constitutional right to life, liberty, and property.
Yes.
So he took it to court.
Oh, boy.
And it got through, something went through the trial court, but it got to the appellate court. I think he lost at the trial court, and he appealed it to the appellate court. It didn't get farther than the appeals court. But our appellate court, and I'll tell you what, our Tennessee courts are top-notch. I mean, good old boy Tennessee, but these courts, they know law, they understand it, and they sometimes surprise even me. But they are usually, if not always, right on the money, especially from a legal standpoint. Not always what you want to hear, but it's the right answer. It's not maybe the most popular answer, but anyway, and they analyzed this, and they said, look, and here's some of the buzzwords they used. They said, look, this is a revocable living trust. And one of the phrases I like, they said, you are a beneficiary of a revocable living trust at the whim of the trustor. Means if you want to disinherit somebody, disinherit them. We'll enforce it. If you want to give them something, give them something. We'll enforce that.
Yeah.
And so they said then they went into trust law. And so I'll just paraphrase, but when they went into trust law and said, the trust code tells us that we will enforce the trust instrument. Now, we do have a thing called the trust code, and they even went on to say the trust code is really just a bunch of default values. So if you have a trust and you don't mention something, and we need to fill that gap, we go to the trust code and we use the default value. A good example of a default is if you say, I leave it to my kids. You have three?
Yes.
You have 3 kids, and you don't say, what happens if one of them predeceased you? I mean, it could happen, right?
Yeah.
But you don't say anything. And that actually happens. You pass away, a third goes to a child that has been predeceased. Well, if your trust is silent on it, we got to fill the gap. The way we fill the gap is we go to our uniform trust code, and that says if that happens, it goes per stirpes, which means that third flows through the deceased child to his direct descendants.
Yes.
Well, that's a way to go. There's other ways to do it. But so the court went into great length to say this trust code doesn't control how things does. It just fills the gaps from what the instrument itself says. He says, we are bound to enforce what's in here.
Yes.
And they said it was clear. Now they talk about the intent of the trustor. The intent was made perfectly clear by natural construction of language and statutory construction. It's clear what she wanted. If he was married to this woman, it goes into trust. If he wasn't, he gets it outright. I said, unfortunately for him, he was married at the time, so we are going to enforce exactly what it says. And so we, case denied for, they ruled for the estate. And so that's kind of a bizarre condition when you think about it.
It is a little
But, I mean, it's one that you can relate to, I think. And so, but the court was way on board with the fact that, look, we will enforce what's in this document. There's no standard one-size-fits-all. It's not like search and seizure. Is this search valid? Well, here's what makes a valid search. Here's what makes an invalid search. It's not it's not a standard procedure. They said, well, we'll have to read the trust, but we're going to enforce whatever's in it. So whatever your complaint is, if the trust says they can do that, that's what we'll allow. So the answer is, can you enforce these terms and conditions? The courts will enforce them absolutely. Yeah. Again, the trustor's intent is paramount, absent compelling evidence, and compelling evidence is a high standard. We shall not disturb that intent. And because one thing is, you're not here to argue about it anymore.
Yeah.
That's why they're putting such great weight on it. And when you have a revocable living trust, you can change it anytime you want, as long as you're still alive to do it. And so the court takes the position, and the legislature takes the position that if you wanted it changed, like this case, so they're saying if mom didn't want that, she had her entire life. They pointed out the fact that she wrote this trust 10 years ago, before death. If she didn't want that, she would have changed it. She's smart. Okay, it's like, well, how do we know that? Well, she's smart enough to write a trust. She's smart enough to know what she wants. She's smart enough to put the terms and conditions here of exactly what she wants. Then she passed away. If she wanted something different, she's a reasonable person. She would have changed it. Yeah. And that makes perfect sense. You don't want to get in there and argue and say, well, she changed her mind. She just never got around to changing it. They're not going to buy that crap. It makes sense what they say. And so the answer is they will absolutely enforce what's in it. So that's why I tell people, when you do a trust, and it's important for you to how you want your property distributed, whatever that how is. Yeah. This is how I can make sure and guarantee to you that that's what will happen. Because of the trust laws that the state of Tennessee has. They are very strong.
That's what I was going to say. That's a testament to the strength of that document.
Yeah, and we are lucky here because we are ranked number 3 out of 30 states as the most favorable trust laws. And so I got people that come from other states that write Tennessee trust just because of that reason. So, we got a lot going for us here in Tennessee when it comes to trust, and those are just some examples of what you can do. I mean, insert your family dynamics here. But now a lot of people say, okay, I got this problem, but I'm not sure how to solve it.
Sure.
So I think I mentioned this before, that if you come to me and want to write a trust, here's the best way to know what to put in it. I say, let's fast forward to the end, and you describe to me what's the ideal end result. Let's not talk about how it gets there. Just tell me what the ideal end result is. Yeah. My kid gets this money, and he doesn't use it to kill himself because he's got a cocaine addiction. Okay, that's the end result. That's the ideal end result. Okay, we will work out a solution that gets it there because we got lots to work with, lots of tools. I really can honestly say I've had a few challenging issues, but I don't think I've yet been able to not come up with a solution. Sometimes they get a little bit convoluted and challenging, but we can do it.
That's interesting. Very interesting.
Here's an example, because we're getting toward the end, but this is exactly what I wanted to talk about today. These terms and conditions you can put on stuff. Yes. What's big in this neck of the woods, and here in Tennessee, we got people that have property that's been in the family for years, sometimes generations. Yes. And it's very important to some people. They say, "Look, I inherited this farm. My dad inherited it."
I see it a lot.
The whole line. You see it all the time in real estate.
Yes, I do.
And it's very important to people that it stays in the family. Okay, and now I have some people that will say, "I'm going to give it to my kids, but they cannot ever sell it." Mm. Now that creates a problem.
That does create a problem.
And the problem is this: there's a thing called alienation, which is the right to own, use, possess, and sell property. And if you say you can never sell it, meaning I'm going to leave you my property, but you can never, ever, ever sell it, never, ever, right? that the courts will not uphold that because that is a restraint on your constitutional right of alienation.
Right.
So it's can they never sell it? Well, there's a couple things we can do. We can conditionalize it. At the very least, we can say, all right, if you want to sell it, I'm going to put a term and condition on it that you have to sell it at least to a family member first. It's called sometimes you hear it called the right of first purchase or the right of
Yes.
first refusal. You got to turn to the other family members first and offer it. Now they got to pay fair market value, but
Right.
they get the first shot at it before you go to a third party sale or try to force a partition sale or something like that.
Right.
So you got to do that first. That's one thing you can do. Now, another thing we can do now. I've done it on several occasions. I've never seen a court case to uphold it or reject it. It's sound in trust law. I think they'll uphold it, but I just have never seen. Might be a case of first impression. I don't know.
Yeah.
Hasn't got there yet. And that is when you write a trust and you distribute property, and the same thing with a will, you have to avoid what's called the law of perpetuities. Which means if you say this property goes to my son, he has to put it in trust, and it goes to his son, then it goes to his children and his children. This law of perpetuities comes up. You can't do something that lasts forever. It has to have an end, right? So what we can do in Tennessee is, you can say, okay, I'm going to leave this property to my children in a trust. The trust is they can use it, they can farm it, they can do whatever they want with it. What they do is they can't sell it. Now, I just said you can't say that, right?
Mm-hmm.
But we've given it to them in trust, and we're going to say, but they cannot sell it for the life of the trust. Well, you see what we've done there? We've
Yes.
created an ending, haven't we?
Yes.
So we've avoided perpetuity because the trust has to have an end. A trust can't go on forever.
Right.
In Tennessee, a trust can last 360 years.
Oh, really? Now
don't
that
ask-
I didn't know.
Don't ask me where that number came from, but when I researched that,
That's going to be a little longer than I'm going to be here.
That's close to perpetuity. Would
Yeah.
you not? Would you not
I would-
think?
yes.
I would too. And so I've done that. I put property in trust. You remove the ability of them to sell it because the trust owns the property. Now they have 200% use and do whatever they want with the property. They can farm it. They can make income and make
Right.
a living off
Right.
it, just like they're doing now anyway.
Right.
It's just owned by their trust because we left it to them in trust. It's kind of like in a trust for their benefit.
They could even put a 99-year lease on it.
They can lease it to people. They can do whatever.
Yeah.
What they can't do is sell it until the trust terminates. And you can make the
That's
trust
interesting.
however long you want it to be, with the exception of an upper cap of 360 years. Now, where that's not the state with the longest. Nevada can be as long as 1,000 years.
Say that again now?
Nevada, we're not. That's not
Nevada.
that's not the state with the longest length
Oh,
of
okay.
the trust. Nevada has the longest with 1,000 years.
Oh, okay.
So, and when you think about it, why would the legislature do that? Well, because they want people to be able to do this.
Yes.
They know what people want to do. The legislature represents us.
So they created language to make it happen.
And maybe they themselves have family farms.
Sure.
But I mean, that's what their constituents here in Tennessee want to do with property. And some of the other states here in the South, that's a big deal in the South. Family land staying in the family. They know that's what we want to do, so they created a way for us to do it. We can't violate fundamental principles like perpetuity and stuff like that, but we can do these things. So these are conditions you can put on it. And when I tell people about this, it's like, wow, you mean we really can fix this problem? The answer is yeah, we can. So
It's amazing.
again, these terms and conditions I'm talking about, you really can come up with your own scenario because the terms and conditions you want are geared toward fixing a problem. You don't do it just to make it hard for your kids to have the money. I mean,
Yeah.
I wouldn't recommend that anyway.
Yeah.
You want to structure it to fix a problem.
And hopefully families have discussed this among themselves and kind of let their heirs know these are the plans. And in the best case scenario, they're all happy with the plan.
I actually have a case where the land is going to a grandson.
Yeah.
And the family, in the grandson's presence, has said, look, we love you. You're our family, but you really haven't shown to us that you're going to work this farm. And, we're handing you an income-producing piece of property. You've got a career when you inherit this. All you got to do is do what the farm does, and we've been doing for years, and you have all the income you and your family would ever want. You won't get laid off. You won't get fired. I mean,
Right.
It's a great gift, but you haven't convinced us yet that you're going to be capable of doing that. So I'm leaving it to you in a trust with somebody else in charge of it. And once we reach the decision that so you can handle it, then it can go
Yeah.
ahead and be yours.
And that makes sense.
And again, Are they punishing the child or are they doing him a favor? Think about it. You are doing him a favor. You are handing him a valuable, valuable asset.
Right.
And if he squanders it, everybody loses, except
Yes.
maybe the new buyer.
Yes.
But I'm just saying everybody loses.
Right.
And if he comes around, everybody's a winner, including the descendants that haven't been born yet.
Right.
Because you can keep the land in perpetuity, just not that trust can keep
Right.
it in perpetuity. So if the new grandchild makes his own trust and leaves it to his kids, and his kids make a trust and leave it to their kids, it can stay in there in perpetuity, but it's not the one trust keeping it there in perpetuity.
Right.
That's where we have to avoid it. So, I mean, like I said, if you put conditions on this stuff, you've got to rest comfortable with yourself that you are really doing them a favor.
That's right.
And now, if they're mad at you for that, then they'll see the light someday.
See it someday.
Like the one that said she blew her inheritance. I wish I'd have seen it earlier, or I wish they'd have made it so I wouldn't have done that.
Right.
But they will come someday. They will say, you know what, you were right, and I appreciate that you did that for me.
Well, let's take a couple of minutes to remind people how to get in touch with you and your office, your website, all those things that could be important for someone.
Yeah, I mean, surely you're not telling me that our hour is over.
Well, we're getting close.
The clock behind you tells me that we are.
We're getting close.
You know, I enjoy this show, doing it here on WDXE 105.3 FM. I like the idea of this talk radio. It's a lot of fun.
It is.
It keeps me on my toes, and questions keep me going. So if you need to get a hold of me, if you want to talk, if whatever we talk about gets your interest up, and you want to talk about me anything with estate planning or elder law,
Yeah.
Call me at Pierchoski Estate Law, Pierchoski Elder Law. My telephone number is 931-363-7222. You can also go to my website, which is easy to get to. It is estateplanstand.com. There you can see my calendar, and you'll see that where my next seminar is. And real quickly, my next seminar is July the 29th. It's a Saturday. It's next month. It's a Saturday at 10 o'clock in the morning. It's going to be over on the square in Pulaski at the Star Theater. Right there, nice,
It's a great
nice
facility.
big venue. It's kind of like over here. We got a lot of room to set up with tables and chairs. So,
Right.
so July 29th at 10 o'clock, and we call it Will's Trust in the Nursing Home. Call my office at 931-363-7222 to RSVP or RSVP from my website. Schedule one of my 15-minute phone calls. We do this where you call and schedule, because if you call, the girls won't always let you through because I'm usually doing something.
Yes.
But you call and you'll schedule something, usually later that day.
Sure.
And when I call back, that my time and attention is dedicated to your question.
Very good.
I'm not in the middle of something where I have to take the phone call, so you give me your question and we'll talk about it. I offer the time freely. Take advantage of it. I'm more than happy to do it. So
363, that's a 931 number, 363-7222.
That's correct.
Also, I wanted to mention, too, if you don't mind me telling folks, that you can be heard on another radio station on the weekends.
I do. Sometimes I'm reluctant to talk about other radio
That's
stations
okay.
already, but
No, we cross-promote. It'll be all right.
Sure. On the weekend, I'm on the one out of Nashville, WTN.
Yeah,
It's
WTN.
99.7. They're Super Talk, they call them. I'm at 8 o'clock, 8 to 9 o'clock. It's the same title, Bulletproof Estate Planning.
Very good.
And, you can tune in on that. I have
Awesome.
quite a
Good.
following with that
We talked
show.
about that last week.
Yeah.
Stan Pierchoski, everybody. Estate Plan Stan.
And always a pleasure, Jeff. Thank you.
All right. God bless, buddy.
This is WDXE, W287AA, and W237FD Lawrenceburg. Broadcast services of Prospect Communications.
The Supreme Court may be about to rule. I'm Dave Anthony, Fox News. There are several key cases still to decide before the justices end their term this month, from affirmative action to a challenge to President Biden's plan to wipe out thousands in student loan debt for millions of Americans. 1 year after the court's ruling allowing states to ban abortion. So later today,
the president and vice president are expected to win the endorsements of major abortion rights groups at a political event. Planned Parenthood Action Fund, Emily's List, and NARAL are making early endorsements. They raised a profile of the abortion debate a year after the Supreme Court struck down the Roe v. Wade precedent.
That's Fox's Jared Halpern. House Republicans are considering impeaching President Biden. Two committees will investigate his